continue to recap Atlanta, Georgia, Fulton County racketeering trial against Jeffrey Williams, also known as Young Thug. Just a reminder, court dark today. Jury supposed to be returned on Monday, and hopefully we'll hear the testimony then, the new refreshed testimony of Kenneth Lil Woody Copeland. After a month and a half out of the loop, the jury will be in their box. We're gonna shift gears just for a moment here and talk about this woman, Judge Paige Whitaker, the third judge in this case. She just wrapped up her second week of motion hearings to prepare court for the jury's return on Monday. This week we saw her kind of put her foot down following several complaints from the defense team about discovery violations from the prosecution. Check this out.
You acknowledge, yes, we could have gone ahead and let the defense know we were going to try to get this plotted. You just didn't. And I guess what I need to have happen going forward is that as this trial is going on, first, if there's anything outstanding like that, whether you've got results back or not, or if you're just like, after somebody testifies, you know what, this would be a good thing. Okay. Share it in a timely manner, which is like, not necessarily at the time it occurs to you, but at the time you decide to do it. Okay. Don't wait for the results to get back. Don't wait till you're going to call the person to the stand. At the time you say, we're going to do this, you give that information to the defense, okay? And then when you do get the results back, you can say, we're not going to use it after all. Or we are going to use it, here's the result. And that is going to go, be the rule, be the requirement moving forward for everything. So if there's anything out there right now that's kind of in progress, okay, tell them about it. Okay. And moving forward, as things come up, when you decide I'm going to be doing something about this, tell them about it, okay?
Can I ask you a question before you do that?
Sure.
Is this something that is not already included in one of the numerous motions for mistrial or to disqualify these prosecutors?
I don't think so, actually.
You don't know?
I said I don't think so.
Okay.
But I'm not sure.
Go ahead,
But this
share
is
it.
specific about discovery, disclosure,
All right.
and timely disclosure. The state's been caught before. Specifically, I remember a late discovery disclosure that once it was disclosed, it actually had a comment on there that was supposed to be internal that said, do not serve yet. They did it on purpose. And how many times can you say, oops? How many times can you repeatedly, systematically make the same mistake as an experienced litigator and say, it's not bad faith? Okay. Your Honor, I'm just asking that the rules be enforced. Because if they're not really rules. They're just aspirational.
All right, I understand. And we are instructed ad nauseum by our appellate courts, they probably won't like my use of that term, that exclusion of evidence is an extreme sanction, and that prior to a trial court instituting that as a sanction, the solutions that need to be thought about include a continuance, which is not going to happen here because we've been on a continuance for a while here anyway. A continuance here, it's, no, they cannot bring it up next week. It needs to be way far down the road, which they are representing that it's going to be anyway. So it'll give y'all time to look into whatever it is. And I understand what you're saying, and I hear you. And the answer to how many times can it happen? Maybe 0 more times.
That's right. 0 more times, y'all. Y'all gonna make me lose my mind up in here. So it's very interesting. Katherine Lizardo, Aaliyah Roberts, Katherine, this is like a substitute teacher the class is taking advantage of. They know what happened. They know what they got away with before. They know what they didn't. I don't think she's being strict enough with these kids.
I think so too. I mean, she's the third judge right now, and I'm sure she's aware of what has happened with the previous judges as well during those court hearings. And this issue of discovery violation allegations by the defense team has been going on. However, and that's the big however, we have to also consider that this case is a RICO case. It's unlike other cases. And so it seems that the witnesses, the evidence are living witness list, living evidence list, meaning that there are new things that come up as each witness actually testifies. And some of these witnesses might be arrested and or get a plea deal at some point or suddenly accept an immunity deal. Copeland's immunity deal happened the night before he testified. So all of these things are happening as the trial is going on. That's why the judge cannot impose that extreme sanction of excluding evidence. It has to be a case-by-case basis and also a common sense basis. If you are going to use that evidence or that witness, you have to produce it to the other side. So all aspiring law students.
Yeah, I mean, you know, it's just such common sense. I think she's being very political here. Not necessarily as judicial as she should be. She wants this to just let's all play nice and let's go out to recess and then come back in and study hard. I don't know. So Aaliyah, you have the judge who is now, and as a foundation to the question I'm about to ask you, you know, Judge Glanville was looking at these really motions in limine as the witnesses came along. Instead of doing all of them pre-trial, he would say, okay, who's up next week? And then they would address those issues. That's why this judge is now forced to do motions in limine months into a trial. It was just a horrible thing to start. She's inherited that. How do you think she's doing with that and other issues?
I think that she's doing a great job. I know there are some people that may disagree with me based off of the fact that she might have, you know, could do more as far as sanctions to the prosecution. But I think she has to clean up a big, beautiful mess, right? This case has been going on for 11 months. All of these, exactly what they're called, pre-trial motions, should have been done before trial. But because she's the third judge on this case, she's inheriting this case, she has to herself catch up and figure out what's going on. I'm sure she's read the transcripts. I'm sure she's read a lot. But as you can imagine, there's so much evidence. There's so much for her to review on top of the other cases that she has going on. So I think she's doing the best that she can with what she's got. She doesn't have much, right? But she's trying to get housekeeping in order. She's trying to organize everyone and say, listen, what happened before, it's not going to happen going forward. You're going to turn over the evidence. This is not trial by ambush. Get it done right, because I don't want to do anything more than what I have to do.
Yeah, I think, you know, Katherine, real quick here in 30 seconds, we'll see how different she is in front of a jury. And with, you know, we've seen her with witnesses without the jury in place, but what do you think her demeanor will look like in front of a jury?
I think her demeanor will be similar as well. Like Aaliyah mentioned, I actually like this judge too in terms of her temperament and just how she addresses the counsel here. So I think she will be professional as well and more compassionate to the jury, considering how much time they've spent on this.
Yeah, well, we'll see. We'll see. You guys are much more cheerful about the whole process. I think she should be tougher. Okay, I'm going to thank and excuse Katherine Lizardo. Always a pleasure. Have a great weekend. We'll see you next time here on the network. Aaliyah is going to stick around. Hey, you heard of the suitcase murder case? Oh, man. We're going to talk about it after we take a bit of a break here, so stay right where you are. This is Law and Crime. We'll be right back.